I'm sorry about that, Sam.
But it's a step in the right direction.
Yeah, that's true.
Hello, everybody. This is Attorney Sam Shihab with the law firm of Shihab Burke, and with me is
Brian Burke from that very same place here in happy old Dublin, Ohio.
Absolutely. It's 6 o'clock Eastern time, and this is the time when we get together for an hour to talk about some immigration stuff, answer your questions.
Stuff?
Answer your questions and see what else we can learn from each other. Today's topic, the first 10 or 15 minutes of our presentation, is going to be focused on a new H-1B CAP registration for fiscal year 2026 and challenges facing that H-1B CAP, and then roll and answer your questions as they come to us. And by the way, today we have started a new website.
Yeah. Oh, it's good? It's good live now?
It's live. It's a very simple website. It's called immigrationquestions.us.
Yeah.
And you know why .us?
Because it's a domain nobody wants and it's a very nice price?
Because it is a U.S. immigration law.
There you go. That works.
And because of that as well.
Yeah. I wouldn't want to pay for the .com of that, yeah?
Well, it's gone.
Yeah.
So we have immigrationquestions.us.
Yeah.
That is a very simple website, and the only purpose of that website is for anybody that has a question during the week. You don't have to come in and the last minute type it in. If you remember a question, you go to immigrationquestions.us, and we're going to put it in the description and drop your question, and we will let you know if we're going to answer your question and when we're going to answer that question.
Yeah.
So you will have the opportunity to log in and listen to our video. Immigrationquestions.us. But back to our topic, new H-1B CAP challenges, fiscal year 2026. There's a change in the law.
Yeah. I think it's interesting. So we have new H-1B regulations that went into effect on January 17th, and we have a new H-1B registration CAP coming up as it does every year. And it's been running through my head, how is one going to impact the other is the short answer there.
And they do.
Yeah, for sure.
Just to get the foundation, Brian, the registration this year is March 7, 2024 until March 24, 2024.
Yeah.
Okay, now I'll start again. March 7, 2025.
It's on the screen, they can see it too, but yeah.
Until March 24, 2025 for fiscal year 2026.
Yeah.
This is for jobs begin October 1st, 2025, which are the jobs beginning in the government calendar fiscal year
2026, which begins on October 1st, 2025. Yeah, it's always confusing. Yeah,
exactly.
Yeah.
What we do during that short period of time is couple weeks, is we register people. We enter their name, their passport number, their date of birth on behalf of the company, and they go through a lottery. And then there are two lotteries here to talk about. The first lottery is the Master's CAP lottery. That goes in first. People with a U.S. master's degree, certain master's degree from nonprofit and accredited universities, they are registered first, and they get first dibs at the registration.
Yeah, they get a private pool of 20,000 visas, H-1B visas, just for those folks. Yeah.
And then whoever not selected from those U.S. master graduates, qualified U.S. master graduates, are thrown in the the rest of the general quota, as people refer to it, and they compete over the bigger pool of H-1B petition, which is approximately 65,000, a little bit less than that, minus certain allocations to certain countries, plus certain visas not used from prior year, with very minor tinkering with the numbers, not worth mentioning. But then a second lottery is drawn, and that's the H-1B CAP registration. And then people apply, and they register more people than the number. So I think last year was over 100,000.
Yeah.
That a number exceeding 100,000 that they registered. And based on who applies, there could be a second lottery or a third lottery to fill the...
So when you say they register people, you're talking about so even though there's 85,000 visas available, they told over 100,000 that you've been selected to file a case, and they do that based upon the premise that some of these people won't actually file those cases, some of these cases are going to be denied, so in the end, only 85,000 visas are actually issued, right?
Yes.
or however many they have available, give it whatever
Yes.
that number is.
And the selection rate has been about 28% or so.
I have the data. We ran some numbers for the past couple years. 2021, 45%. 2022, 42%, and then 23, 24, 25, around the 20s there.
Yes.
Sam, have you thought about what you? Well, I guess we have thought about it, considering it's in our slide. But some of the things that are sort of factoring into what the selection rate is going to be this year is one. An important rule change is the registration cost goes up to $215 per person.
Yes.
Per registration this year. There are the new H-1B rule changes that might scare some people off, which is something we're going to talk about in a minute. And then there's like the political climate, the economic climate, and the new sort of beneficiary-centric rules. The thought is that we may see a better selection rate this year than we did last year. Do you think that's reasonable?
Yes, I think it's reasonable to say that there will be an improvement in the numbers. Just the $210 or $15 a pop.
That's enough to stop.
I think
the
people to be a little bit more considerate, a little bit, or careful, not throwing a bunch of applications where they're not sure about the results. Now, this will be the second year, Brian, from what they call a beneficiary-centric selection, where it is one passport number, one person, one date of birth, one selection. If it's 20 companies applied or one company applied, doesn't matter.
So if John Doe puts his, has 20 different companies register for him, he does not get a better chance of selection in the lottery, because if they select him through one, they're going to select him through all those companies, right?
Yeah, one person, one selection,
one count,
one count,
one slot into the
one
cap.
chance. And therefore it doesn't matter.
Yeah.
And this is a simple solution to a big problem that they've had, that they've created themselves, and now they solved it by a very commonsensical approach. Now, another change is the cap gap begin date, Brian.
Yeah. So H-1B CAP gap is a pretty long-standing concept. It's basically, hey, if you need it, and you're on F1 OPT or STEM OPT, you get an extension of your H-1B, your F work authorization and your status too. It used to be through September 30th, through the first day of the fiscal year, which would begin on October 1st. Now they've said, great, we're actually going to extend this until April 1st of the year of the fiscal year. Meaning, the bottom line is there's sort of less of incentive, less of a need for premium processing for people who are registered in the lottery to basically, get their H-1B approved before October 1st so they can avoid work gaps, which is kind of neat. Kind of a nice little gift in there. I don't know. I don't really encounter a ton of people relying on the cap gap, though. I mean,
there are people.
Yeah, I guess the short answer is it's going to help somebody out, which I love. I won't make any complaints about it.
Yeah.
So
those who have early expiration, let's say April 6th or 7th.
Yeah.
And the window of filing comes in, they got to start preparing their case sometime before they even know.
Well, you're understanding something. You're highlighting something that I didn't mention when we talked about the cap gap. It's that in order to take advantage of the cap gap, your H-1B cap petition must be filed before your
expiration
of your EAD. Yeah.
The expiration of the EAD.
And you're saying basically, if you have a scenario where your OPT EAD is ending on April 6th or 7th, and you get a filing window that begins on April 1st. You better be talking to your immigration attorney out there and saying, no, guys, we can't wait until I'm selected. We have to presume that I'm going to be selected so I can file an H-1B on the absolute first day.
Well, the LCA takes 7 days.
Yeah. And
so if you wait, you may not be able to file the case timely.
Yeah. You have to have that LCA in before you're selected, essentially.
Yes.
Yeah.
The other change is the requirement for the job has to be bona fide job. This is really a codification or this was the practice all along. It has to be a bona fide. You cannot just file an
H-1B for fun
lottery because you have an extra $20 in your pocket. You have to have the intention, the true intention of hiring this person for a job should this person be selected. Now, it doesn't mean that you will. It doesn't mean that you must. It only means that when you file this lottery, you really thought that you would like to hire that person if they are selected in the lottery, and that's the standard that they have to meet.
Yeah. Well, congratulations, Sam. We have touched upon what is, I think, the most intriguing and potentially challenging part of the H-1B CAP registration for this year, or more of actually filing the case. They require you to have a bona fide job, and part of the new regulations is they say, hey, we can request, contracts and other similar sorts of documentation to confirm there's a bona fide job available for you. And this is what we were talking about last week, well, us in the conference room here last week. So if you're filing an H-1B case in the window from April 1st until June 30th, right, for work starting on October 1st, it might be a problem for some employers to show that they have work available for their employees as of April to June for work starting in October. Maybe less so for people, if you have an employee, you already have them working, presumably you're going to have evidence of work availability for them if they're in the United States. But if you're doing an H-1B CAP for somebody overseas, like an IT consulting company, let's say you have an IT consulting company employer, you're working for their foreign affiliate, and they would have bring you to the United States on an H-1B visa to do something different, bottom line is IT consulting firms, as we read these regulations, are most likely to get scrutiny on this, and might have difficulty getting those H-1B approvals because, how can I document I'm going to have work available 6 months out? That's just not the way our industry works. I think that's a compelling, it's an interesting thing, I guess.
So, so we're talking about the expectation at the time you file the visa lottery and the expectation at the time you file the H-1B. Yeah. And you and I have agreed that these expectations are different.
Yeah. So have I jumped the gun then?
No, you haven't jumped the gun. I just want to make it so people understand it clearly. So there is an expectation. The government has an expectation of you when you file the lottery. Mm-hmm. That legal expectation is different than when you file the H-1B.
Correct.
Yes.
Yes. Agreed.
So those are. So what are the differences, Brian?
Good point.
Between the expectation at the time you file the lottery and the time you file the H-1B.
So maybe I did jump the gun a little bit. So at the registration time, they expect you to have a bona fide job available, which means.
So what does that mean? Yeah.
Just it's good faith intent to hire, as far as we can tell. I intend to actually file an H-1B.
Yeah. Don't throw in these lottery cases and you have absolutely no intention of hiring.
Yeah.
That's really what you need. The bona fide or bona fide job, or that means you really are reasonably in that business. You're taking some effort in understanding what the obligation is to hire, and you really plan to hire this person, and you're just not doing it because somebody asked you for a favor, or you're just basically not going to hire him, but you're just trying to kind of learn how it works. It doesn't work that way. Yeah. So that is the time of the visa lottery, Brian, right? Now, what's the difference between that at the time of visa lottery? Now, this person is selected. What's the expectation at the time of the H-1B petition? Non-speculative employment.
Yeah, and evidence of it. Yeah.
So different words.
Yeah.
We're using different words now. That the position that the employer must have a non-speculative offer job for this person. Yeah. Meaning that there is a real job.
Yeah. And in what they say in the new rules is that we have the right to ask for contracts and other sorts of similar documentation to show availability of work, and that's where
as of the H-1B effective date.
Yes.
But it has to be available as of the H-1B filing date.
Yeah. And
that's really different type of standard than the visa lottery filing.
Yes. Correct. Yeah.
Yeah. Okay.
Yeah.
And so it says here, I think there's some good language. I'm going to read it here, Brian.
Yeah.
So the bona fide employment requirement does not obligate a petitioner to identify every third-party client for whom the beneficiary would provide service.
Yeah.
Rather, a petition must demonstrate at the time of filing availability of a bona fide employment and at the time of the visa lottery, right?
Yeah.
That it is the petitioner must show that the employment is in a specialty occupation, actually likely to exist. Yeah. Actually likely. I'm not sure. I mean, I understand the term likely to exist. actually likely to exist is silly, but
Well, I think I just, and I'm going to bore everybody for a split
Emphasize.
second. No, I think they may be talking about the preponderance of the evidence. You can't, you never have to prove everything to 100% for them, but you have to prove likeliness, and preponderance of the evidence standard, as it is in immigration matters. So I know we have a couple graphics here. You want to talk? I know we was talking about site visits.
yeah. So let's jump on the site visits here.
Yeah.
And there's a couple things.
I guess this is kind of relevant to the whole subject of verifying work availability. So
Yes.
bona fide employment must be available. And one thing we talked about was, well, okay, we might ask you for contracts, and site visits is a part of
Yes.
how they might verify as well.
So site visits are mandatory now. That doesn't mean that every case will receive a site visit. It means that if there is a site visit, you must cooperate and answer the question. Before it was not mandatory.
Yeah.
So you must, otherwise your case will be denied and the employer could be investigated. So the requirement for site visitation is a choice the government makes. You are obligated to fulfill that, whatever they need, give them what they need at the time they do the site visit.
Yeah, and if we're talking about H-1B CAP cases, I think it's some really potential for some, let's say, interesting scenarios to pop up. If your employer says, okay, he's going to be working for us, I'm going to think about the pure IT consulting scenario. It's probably the most difficult, most scrutinized H-1B scenario. If they say, well, he's going to work on site with, our client who's outside, right? And they send somebody to this client site and they start asking questions. There's always a problem with this. So it's, who do they talk to at the client site? I was thinking maybe they might not have knowledge, but all again it takes them is to just talk to the wrong person at the client site and say they're not working here. And the answer is, well, maybe it's been arranged for them to start in October, and that sort of thing is. I guess it's maybe more of a fundamental problem with a site visit program. They're never the best.
So there's a lot of discussion on this issue, and probably we're going to reserve it to a separate.
Yeah, that's fine.
It's site visitation, what to expect, and what the government is expecting from you now in light of these new regulations that went out, because there's some really interesting stuff in there. But let's, within the context of this H-1B CAP presentation, site visitation are mandatory even to third-party.
Yeah,
but it's not part of the registration, lottery registration. There will be no site visit on that. It's after
they don't have the information to do that. But when it's not super common that you get like a site visit on a pending H-1B case. One you file, but oftentimes sometimes you do.
You do. Yeah. So there's interesting statistics they shared with us on the H-1B site visitation that, again, we will revisit. So that one talks about the number of cases that they have filed, and they have found, there's 9,000 in 2019. They did 9,000 site visitation, and then significantly down in 2020, 21, and 22. But the percentage of fraud non-compliance is 15%, 21%, 21%. So it's 1 out of 6, 1 out of 7, 1 out of 5 cases, which is, I think, in my personal opinion, is impossibly to be correct. These are not correct information. I think this is an agency that's trying to justify its own program.
Yeah. We've handled site visits in this office before, and I honestly cannot ever remember seeing a revocation in Noir that after us. Well, maybe here's maybe how they explain their numbers. Okay, we found non-compliance. They issue the Noir, and then a bunch of guys like us come along and say, no, guys, they're in compliance, and they never actually revoke the cases. I can't remember. I can't in my memory remember seeing one.
I'd like to produce my own chart of the number of cases in which the government has claimed to be fraud, and the percentage of time they are wrong.
About 100%?
And about 99%. Out of 100 cases, there may be one case that's really true and honest fraud. 99% is basically paranoia.
Yeah, I was going to say lack of imagination. The classic one is, we went to the work site and we couldn't find this person, and the answer is historically, well, we filed another H-1B for them, you guys, and
or this employee is terminated and is no longer with the company. Or the person you talk to didn't care because this is a third-party site, or they did not let you in the building because you did not have an appointment, etc., etc.
Yeah.
So these fraud percentages, although now they're inked on the Federal Register and published, I very highly question its accuracy.
I mean, maybe there's companies out there getting hit with fraud and noncompliance, but I literally
They're
cannot.
not in this office, that's for sure.
I can't think of one. Occasionally, somebody comes to us and says, you know, something didn't go right. But honestly, if you explain, you know, here's what happened and here's what we did to fix the situation to a USCIS officer, it's fine.
I find the lumping of the fraud and non-compliance to be highly offensive.
Yeah.
Highly offensive because there's a huge difference between non-compliance and
nobody
fraud.
can achieve perfect. I mean, perfect compliance is something to be strive for. Yeah. You cannot achieve perfect compliance.
I found it to be repulsive.
We had a payroll processing error. That's non-compliance, you know. Yeah. And I say, well, here's what I tell the client. I say, well, yeah, technically that's an issue, but you know we cannot control that now. All you can do is you know put a Band-Aid on the past, and if the government asks questions, you explain to them what happened because perfection can never be achieved.
Yes.
But yeah.
I don't know. I think we've covered the issues, Brian. Is there anything else we need to talk about?
I think you have one more.
I think this is probably the, so this is they're given the average time they spend on every case trying to quantify it, you know, I'm not sure it's of a value, but okay, so they're spending about an hour per person on average.
On these site visits. Well, I guess maybe.
And by the way, somewhere else is the salary, how much those guys are getting paid, which is ridiculous, $80,000 a year.
The site visit guys?
Yeah.
Oh, interesting.
Yeah. Yeah, but when I was looking at their calculations, like $80,000.
Well, I guess one thing to say about those that data is that's data for 2019 through 2022. Do you think the instance of site visits will go up now that they're mandatory? You know, this is a compliance-minded administration. Do you think they'll be hiring more on H-1B compliance, just as they're hiring more people at the border to protect the borders of the U.S. employment industry from unlawfulness?
That's an excellent question. I don't have the answer, but for me is why the big drop in numbers. I mean, why? I mean, I don't understand how they make decisions.
Well, I would say.
I mean, I don't know.
I guess my answer for it is, man, they really don't seem to have an interest in employment immigration, and I just can't imagine them saying, you know, we're going to do a bunch of hiring in immigration for, you know, if a politician is trying to get somebody excited, we're going to clean up this border, stop letting, or we're going to.
We caught so many fraudulent people. Everybody says, oh, look at this H-1B program. It's riddled with fraud. Look at this 20% fraud and non-compliance.
I think for the average person, you know, we're going after alleged fraud, you know, payment issues, yada, 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 for temporary workers in the United States on specialty occupations. I don't think it has, for lack of a better word,
just like an IRS audit. It's like an IRS audit. You know, an IRS audit comes in, they look at your books, you know, you're an employee, you're trying to comply. They're wasting your time. They're sitting in your conference room for 2 days, 3 days, and you're paying money to an accountant, and then they come out and they say, $300 here, you haven't paid taxes, and you immediately write the check. If it takes $300 to get you out of my office, here's $500, get the heck out of my office, and then they'll take it and say, non-compliance. This guy was non-compliance. The only reason you paid the money is because you're costing you so much more to keep this IRS officer in your office.
No, yeah, I mean.
Now you become non-compliant, and then they turn it to Congress and say, look at our program. We've sucked money from people, how much money, and we went after them, and we need to hire more agents to do more of that.
I have to just bang it again. It's, you know, there is no employer out there in perfect H-1B compliance. It
doesn't exist.
Yeah, and there's human beings involved in the process, and that's
because some of the requirements are ridiculous.
Yeah. Well,
you know, it doesn't help anything.
Yeah.
Anyways, so this is the H-1B CAP, guys, in a nutshell. Let's jump into our questions and have fun with questions, and maybe we can go into maybe next week. We'll get some of you guys throw in some questions into our immigrationquestions.us, and we will bring them here, and we will.
We'll have some fun. It's fun to buy a website every now and again just to see what happens with it.
It's a simple tool to get you guys to ask questions during the week.
Yeah.
All right. So let's take the first one.
Yeah. From, well, Sam, I guess we should sort of have our sort of little bit of disclaimer here about our questions. So we're going to answer some questions, and we are going to answer some questions, Sam. But please keep in mind that just by us answering these questions in this live and personal venue here, that this obviously doesn't create an employer-employee relationship between you and us here. We're only getting a snippet of information, and there's just so many more questions to ask. And as you see, as Sam and I talk here, we're not going to even agree upon the meaning of your question, let alone the answer to it every time. So we'd always encourage you to, if you hear something here you think is interesting or you'd like to know more about, talk to an attorney of your choosing. There's tons of great ones out there. Find somebody who specializes in employment and immigration, presuming your question is employment related, because maybe like 5 to 10% of immigration attorneys do employment immigration, as in my estimation. At any rate, talk to an attorney of your choosing, because you owe it to yourself. It's your future in the United States, and you got to protect it as best you can with real accurate information.
So Sneha Mehta has an excellent question.
Yes.
Hi, Sam and Brian. Got a green card in 2021. Went home and spent 5 months, 2 months, 1 month each time, making sure it's less than 6 months each time. I want to travel 2 times in 25 and 2 times in 26, or maybe the other way around. And the question is, I guess her question is, does this frequent travel create issue for citizenship, or at point of entry when I am leaving the country for frequent trips, coming back again, I am also making sure that my stay is 2.5 years out of 5 years. Thank you. All right. Fantastic.
There's so much to unpack here.
Yeah.
She's asking like questions about 2 types of issues, essentially.
Yeah. And people mix them up, and people don't understand them.
Yeah.
So this is a great opportunity to spend a minute or two, and maybe to make it easy, I'm going to take the green card, and you'll take the citizenship.
Good. I was hoping that. I wanted to
split it. So let's talk about green card. A green card preservation is your intent. It is your subjective intent to call United States is your place of residence. The government has no ability to read your intent, and therefore objective rules were created. Rules based on number of days out of the country were created to interpret as a guide, to interpret your intent. But ultimately it's your intent. If you intended to leave the country and make it not your home, and abandon and close your shop and close your bank account, sell your car, sell your house, and leave.
Permanent residence right there, technically, yeah.
Technically, you may have lost your permanent residency the moment you left the U.S. Therefore, we look at your outwardly travel as a read into your mindset. That's really what the rule is. And the rule goes as follows. You have a more than 6 months outside the United States and less than 6 months outside the United States to create a presumption in the law. The law assumes certain things based on your travel. Less than 6 months, the law assumes that you have not abandoned your permanent residency. It doesn't mean that you haven't. It's just this is the starting point of the inquiry by the government. The law gives you the benefit of the doubt when you're coming to the United States. They assume that you have not abandoned. Now, let's assume you've left the country, and then they're searching your luggage, and then they open this letter you signed and dated that has language that I now consider my America not my home country, and I consider Spain or any other country as my home country because this, and that. I have done this, and you sign and date it. Even though you're outside the country for less than 6 months, that letter will override that presumption. So the presumption in the law, the beginning of the analysis, that you have not abandoned your permanent residency less than 6 months. Between 6 months to a year, the presumption, the beginning of the analysis is that you may have abandoned your permanent residency, and the government could ask you questions. And the burden is on you to prove otherwise. No, I did not. Here's my bank account. No, I did not. Here's my car. Here's my car insurance. Here's my warranty deed on my house. here's my letters, here's my other family members are here. So you can override that. So this is the rule, the 6 months and the 12 months. It's a guide. It is not really the rule.
You got less than 6 months. You're golden. Well, not golden, but the presumption's in your favor. More than 6 months, there's a presumption against you. Over 1 year.
And that's the third one.
Yeah.
So over 1 year. Brian, you're dying to kind of say it, so I'm gonna give it to you.
They can consider your green card to be, well, it is under the law. It's invalid. You've abandoned your permanent residence.
So you lose your right to travel back to the U.S.
Now you do, but if I had a nickel for every time somebody called me and said, Brian, I left for a year and with my green card and they let me back in, I'd have a big old pile of nickels. But
we're talking the law because they don't catch it every time.
Yeah.
They don't catch it. Now they're better in catching it than before. But the rule is that card has the right to travel back to the United States. That right on that card falls if you're outside the United States continuously after 1 year. And you must go to the consulate and request the permission to come back.
SB1 returning resident visa.
And explain to them. Now, you could, and many people have, as Brian said, have gone on the plane and flew in and showed their green card, and maybe they ask them, how long you been outside the United States? Oh, a few months, 2 months, 3 months. Okay, welcome back to America, and then you came in. Well, it doesn't mean that fixed the problem. Obviously, there's a vulnerability, so there's a lot of that goes on. That's not what the law, that's the problem with enforcement of the law, if you will.
Yeah.
So the law is after 1 year, you lose. Now, that's your answer on the green card, and I don't want to take too much time because there's a completely different set of answers on the citizenship side.
Well, the interruption of permanent residence is a problem for citizenship as well. So, for example, if that person who spends 1 year outside the United States, right, comes back in the country, and oops, they didn't catch it. That person has sort of had their permanent residence reset for the purposes of citizenship, and there's a big complicated analysis to sort of look back at your travel history, and it creates questions as to when you can actually apply for citizenship if you do something like that. There's also a question here about 2.5 years out of 5. This is referring to the requirement 50% of the time spent in the United States. So if you're somebody who's eligible for citizenship after 5 years of permanent residence, you have to have spent 2.5 years, half your time in the country in order to actually have a successful application. And that's sort of it is the bottom line.
And to the extent that you have not been outside the United States more than 6 months, because that's severs the continuity of residence, then you have to overcome that if that happened. But let's assume you go in, you file an application for naturalization, and let's assume you meet the 50%, which is 2.5 years.
Yeah.
And let's assume that you put all the dates, and each date is less than 6 months. Typically, they're not going to ask more questions.
Yeah, but Sneha asked the question: does frequent travel create issues for citizenship or at point of entry? And
well, it does to the extent that you cross the 6 months and the 2.5 years.
Well, how about this scenario, Sam? It's 5-month trip outside the United States, back for 2 weeks. 5-month trip outside the United States, back for 2 weeks. You think that's going to cause a problem?
And you have 2.5 years?
Okay, if you have 2.5 years, you're going to be 50% of the time, sure.
So you're 50% of the time, and if you are in and out that much, but each trip is less than 6 months,
you're going to be
You're going to probably survive the citizenship application, but it'll be interesting whether they will want to reopen and look at your green card before they even apply the naturalization. But yes, if you meet the letter of the numbers, I have not seen it an issue. I've seen it more concerned regarding preserving the green card than the naturalization.
I agree. I was jumping back to that. That's what I was saying. The concern was because those customs folks, you've spent how much of the last year inside the United States? That's where you can really.
So is frequent travel again? It's all calculation. It's all state of mind. But the general answer to the general question is yes. Frequent travel generally tend to create more challenging green card preservation and more challenging naturalization.
Yeah.
You need to kind of continuously discuss things with an attorney because let's assume you have a house and property and car insurance and car and kids and family and cousins here and so forth. All that is favorable consideration when you look at the totality of the picture.
I guess I'd also
that's the best answer I can give.
If you plan to be out of the United States for a long time, you can apply for a re-entry permit that gives you the right to re-enter for 2 years, up to 2 years during its validity.
Which I don't recommend.
Why not?
Because it marks you.
Yeah.
All of a sudden now you are a person who have a declared intention to be outside the United States.
Yeah,
So
yeah, but you know what really marks you when you stay out of the United States for
Yes.
more. Believe me, I guess my recommendation for any green card holder is stay in the United States 5 years and become a citizen, and then you're a U.S. citizen as well as a citizen of the world. You can come back whenever you want.
yeah, next one.
Yeah. So MG.
I have an approved L1 extension on EB1C with my adjustment status pending for 3 years. All right. I have my EAD and advanced parole valid until 2030. If I were to get impacted by a job loss situation, what options do I have? Brian.
Portability, job portability under AC 21, and that's the sort of thing, same or similar occupation. Yeah, short answer there.
Yeah.
Yeah. And that's it. I mean, I guess if you don't have an L1 job anymore, if you've been counted in the H-1B lottery in the past.
So what happened to the EB1C, Brian?
Same or similar occupation. I believe portability.
180 days.
180 after it's been pending 100 days. AOS has been pending for 3 years.
Yep.
So there you go. Yeah. I always get concerned. I'm like, it doesn't seem like it should apply for an EB1C situation, but every time I read it, that's what. Yeah. Basically hop on another visa if you want to maintain non-immigrant status or take advantage of portability rules. Yeah. Ooh, 1 of 4, 4-parter.
Ooh. All right, go for it, Brian.
I lost my H-1B job on October 9th, 2024 due to retaliatory separation. Filed for compelling circumstances at EAD and F1 before my 60-day grace period ended. That's good. F1 approved December 30th, 2024, and EAD approved January 14th. Nice. I can't help but wonder if they're going to be approving as many of those in this incoming administration. Currently pursuing my MS on F1, I have a business idea. Good. Since I can't start my business on F1 and self-sponsoring H-1B is tough, I would agree with both of those things. You can't start your business on F1 until you're having an EAD anyway, like a STEM or an OPT EAD. Can I ask my university to suspend/terminate my F1 so I can switch to authorized stay and grant EAD, continues master's, and commence startup?
Well, he doesn't have to ask for terminate his F1.
Yeah.
You have an EAD. The moment you start working on EAD,
That's a very good point. Yeah.
it's terminated. Your
Yeah.
F1 is terminated.
The rules of your F1 are that while you're in school, you're supposed to be a full-time student, and your work authorization is only subject to the authorization of your school for on-campus employment or USCIS through CPT or school CPT, USCIS OPT, and STEM OPT. And if you step outside those, even legally, like with a compelling circumstances EAD, that's when you step out of your F1 status. You're in control of your F1 status for sure. Yeah. Now, Sam, do you like that? Does immigration attorney Sam Shihab like that?
To work on EAD?
To abandon non-immigrant status for the compelling circumstances EAD.
Well, I know what you want me to say.
I know. Well, okay. I'm trying to put my words into your mouth. Is what I'm doing.
You want me to say you don't like it because the person's out of status.
I don't. Those are my words. That's what I want you to say. I want you to say my words. I don't like it.
But I'll give you my words on that.
I have an alternate take. I'm interested.
Well, go ahead.
Well, if it's what you got, if you believe in the thing so much and you think you can get yourself a business going, you're not accruing unlawful presence, and if that business can get going and sponsor you a visa later on, it's not crazy, but think carefully about it, I guess, right?
Yeah, I think
you shoot the shot you have.
I think if he has a good business idea and he believes it works, I think he should pursue it and pursue his legally authorized to work.
So whenever I have a conversation about somebody like this, I'm going to say, well, you ask an immigration attorney question, you're going to get an immigration attorney answer, and that immigration attorney answer, my first one is always going to be maintain your status. But if you turn the volume on that guy down a little bit, I'm not the guy who makes decisions in your life, and here's the upside and here's the downside.
Exactly.
Yeah.
All right. Hari Guru, H-1B Brian. Hi Sam Brian. I applied for an H-1B amendment. in case not to relocate to the new location after approval and plan to continue the current location. Do we need to submit anything to be on valid status? So you file for an H-1B amendment.
This is I love this question so much as it's going into the my valid? I have what's
So
my
you have
valid
a-
H-1B?
So you have an H-1B, and then you have filed an H-1B amendment, and then a new I-94
Yeah.
was issued
Yeah.
for a new location and new LCA.
Yeah.
The prior H-1B was not withdrawn. It remains valid, and that LCA is not canceled. And the question is, can I stay and not relocate?
Yeah. Can
Do
I
I
can I
have-
fall back to the old H-1B, right?
Do I have both options?
And Sam, so if I think back to the Simeo Solutions memo, sorry everybody, it talks about the concept of going back to a prior approved H-1B, but I think I would want to read the regulations on this again because they purported to have codified the Simeo's decision on this one, and thereby I wonder if they say anything explicit about how do you go back, and if they don't, I would abide by just withdraw the new H-1B, and that lets you're going back.
Well, that's an excellent point, Brian, because now we have new regulations.
Yeah.
So, but back on the Simeo memo, obviously that's an excellent point, and I'm going to see if I can get lucky. Which is the
USCIS Simeo memo? Are you looking for it? Or are you looking in the regulations?
I'm looking in the regulations.
Yeah, because I know they reference it because I've read. Fun fact: I've read the regulations, and I know they reference it in there, and that's so you're gonna.
As a matter of fact, I have it right here. So here it is. Why don't you go ahead and take the next one? I'm going to try.
Yeah.
Because I got it on my phone.
Okay. All right.
And it's a million.
Well, do it like a Control F search for Simeo, and I think you might find what they say about it. At least I'm 99% sure they say they're codifying it.
Right, but I was trying to get to the top of the file.
Fair enough. So from Lester, hello Sam and Brian. My priority date is 2023 EB3, April 2023 EB3. When do you think my priority date will be current? Thank you. Prayer hands. Visa bulletin. So here we are. I wonder if that March visa bulletin's out yet. It seems just about prime time for it. Usually they, not quite yet. So maybe sometime this week, maybe next week. But for the visa bulletin, I'm going to presume, based upon your name and the date you're asking about, that you must be somewhere from a rest of the world country, Lester. And there it is. Final action dates for employment EB3. So they are in December 2022 for final action dates, and April 2023 is where you're talking about. Well, I'd say what I'm going to say is go to the dates for filing. Lester, what they have said in the past about dates for filing is that they reflect where the visa availability is going to be for the foreseeable future. The way Sam and I have tried to sort of interpret that is that the foreseeable future is probably this fiscal year. They historically said it was an 8 to 10 month outlook. And if they're saying on the dates for filing that we expect to get to March 1st, 2023, I don't think they're going to get to April 2023 in this fiscal year. My mind would not be blown if they got to you a little bit sooner before in this fiscal year, but it doesn't seem likely in my mind as I choose to view and understand the interaction between the final action dates and the dates for filing. Sam, you have.
So obviously it needs careful analysis.
Yeah.
So this is something we're discussing here, and I like the fact that we can talk about it. So here it says, DHS proposes to add specific reference to request to amend the terms and condition of the non-immigrant stay without a request for additional time, or for as an amendment of stay.
Yeah.
So an amendment of stay is to change. So to me, Brian, it just would appear to me on the first look that it's an amendment to modify. So you might need a new H-1B as the language read, but this is a first read and very quick. The regulation is extremely lengthy. Yeah. But to me, my first read, specific reference to request to amend the terms and conditions of the non-immigrant stay without a request for additional time for an amendment of stay. So they're clarifying it.
Yeah. Well, basically, your logic. So I'm going to maybe put it in. So this person had a stay that's say valid through June 2027, and then their employer filed an amendment to that says different terms until June 2027. And congratulations, you've amended the terms. Thus, it would seem to be that if the final regulations read that way, amendment.
In other words, DHS considers an amendment of stay request as a request to continue to allow the beneficiary to remain in the United States based upon the amended.
Yeah, I mean, yeah. Well,
based upon the amended.
Does that section reference the particular regulation where they add it, or no? I have the regulations.
8 CFR 214.1. C1, 4, and 6, and 7, Brian. So there's a lot of them.
One. Let's see if we can find. I mean, this is just interesting. We've read these regulations, but it's not until that we get asked like very specific questions where we have to go, oh shoot, 214.1 C. B. Well, this could be a while. I don't want to bore everyone. C1, and what is that?
C1. Let me go back because I left it. C 214.1 C1.
Yep, here it is. Extension of or amendment of stay for certain employment based on immigrant workers, blah, 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 blah. An applicant or petitioner seeking the services of an H-1B worker beyond the period of previously granted or seeking to amend the terms and conditions of the non-immigrant's stay without a request for additional time must file for an extension of stay or amendment on Form I-129 with the fee prescribed in yada yada with initial evidence required elsewhere, in accordance with the form instructions. Dependents holding on derivative status may be included in the petition if it's only for one worker. So I think this regulation was always here.
Well, they've changed it. I don't know how they changed it, but they're saying now it's amended. Amend the stay. So the amendment is to change.
Yeah.
Before, yeah.
So I guess the short maybe. So
there's 4 and 6 too. If you look at 4 and 6.
Let's see here. 4. Timely filing and maintenance of status.
No, forget about that.
How about 6? Evidence of maintenance of status, that's the evidentiary requirements. Yeah.
So the language looks like that you have to file an H-1B again. Yeah. To me, my immediate reading.
Yeah, and in this way, so fortunately, for whomever asked this question, Hari Guru, I presume there's Immigration Counsel working on this for you, but it's there's new.
Seems to me the reading of it, Brian. Of course, if I'm doing a case, I would want to print this. I'm reading off my phone, and I would want to read it again, very carefully. But it seems to me that the amendment is a modification, not an additional layer of approved work location.
Whereas if you read the policy which they adopted, it used to say. They used to provide the concept of a place where you don't already, if you want to move to a place where you don't already have an approved H-1B, you got to file an amendment, which created the implication that you could go, well.
Is the withdrawal of the amendment is a reaffirmation of the prior petition?
I think that's a great question for like the AILA USCIS liaison for them to give a really wishy-washy answer for them.
You're not going to get an answer for these.
Yeah.
I mean, my way of looking at this, and I know an H-1B petition is expensive, not cheap, but I'm assuming you're Hari Guru, you're asking for your friend, and the company is making good money. Compliance is a big deal. We are now in an era where compliance is huge. I would not take a chance. My quick reading of this tells me that they're looking at it that an amended petition now is not an additional layer. It is a change in a request to change a prior petition. And once it's approved, it has changed, and you have to change it back again.
Well, I'm gonna just come in and say this is a waste of government resources, because what do you mean? I guess the point of this one is they're going to know exactly where Hari Guru or whoever that question's actually for is located at, right? Yeah. But are they going to have trouble? It's a waste. It's a waste of their resources, I guess. Yeah.
Yep. Let's take the next one.
Yeah. So for a green card holder on re-entry, do they check devices and social media feed? Well,
on a green card holder, okay. So the why do they do that, and where that's coming from? There's a Supreme Court decision, and I forget the citation. That's the recent.
I'll forgive you.
Yes, thank you. That's recent. That says you can do whatever you need to do, and looking through whatever record the immigrant or the foreign national or the U.S. citizen has,
you have practically no rights.
If you have a reasonable suspicion, even if it's a U.S. citizen, it doesn't matter. Now, as a matter of practice, however, we have not seen that, because what are they looking for? If
That's where I wasn't going to that later, because if you're a permanent resident, what? I'm looking for a job. That's not going to stop you. I'm gonna move.
I'm not happy with the current state of politics. That's your First Amendment. So there's a lot of. I'm thinking about leaving this country forever. You're allowed to think, as long as you haven't taken steps. So normally,
what could they find that would make you ineligible for entry? And
and even if they're questioning whether or not you've abandoned your permanent residency, the only right they have is not to deny you entry, is to refer you to an immigration judge for a deportation hearing or a green card loss hearing. So which result if they agree to be deported from the U.S. So there is really no reason to do it, and they don't do it as a matter of practice.
Don't have evidence of your crimes in your phone, but
if you are a U.S. citizen and you are suspected of being a
smuggler,
a terrorist of some sort,
all right, or terrorist too,
or a smuggler,
thank you,
they are going to tear everything up.
U.S. citizens aren't immune to having their luggage searched if they think you have drugs in there,
So if the person refuses, what happens? Arrested? Denied entry?
Let's see here. Well, depends upon.
No right to counsel.
No, you're right. No right to counsel at the border, but denied. I mean, I don't think
they
it's
can't
like.
deny entry.
Yeah, I don't think they're likely to deny entry.
We'll create a nice dilemma for them. Which we don't have to solve today. Let's take the next one.
Also from Sweet Seller. How long can green card holders stay outside the country? What are the rules for duration of the stay? So we sort of covered
We've covered that one. Basically, it's Sweet Seller. We just talked about it. 6 months is presumption. If you're outside the country for more than less than 6 months, there's a presumption that you haven't abandoned. More than 6 months, you have. And you might want to rewind for about 10 minutes, and you will get a comprehensive answer on that question.
Sort of a follow-up from Sweet Seller. For green card holder, dependent child turned 20, student, part-time worker, is it okay from future naturalization perspective to have this person be claimed as dependent on tax filing with the parent?
No impact on naturalization. However, the IRS code allows you to maximize on your taxability or lack thereof or deductibility. You can do it. No impact on the child. Or,
they don't have to
ability.
be independent to become a citizen. They just have to meet the requirements for citizenship.
Would that be a good answer?
Okay. I occasionally get questions about. I got a question just consult earlier last week rather about I'm on H-1B status. I have questions about my tax return. And I said, you're definitely not talking to the wrong guy. But if you find yourself somebody who prepares taxes and it's probably an immigrant themselves, that's the person who's going to no doubt prepare tons of these things. And that's.
Yes.
Oh, we are misters today, Sam.
Thank you, Jadamis. Hello, Mr. Shihab and Mr. Brian Burke. Thanks for the direct every Monday questioned. Saw an article regarding employment and says that backlog is so massive that visa bulletin can only advance 3 months every visa bulletin insights. Any insight? Wow, that's a conversation for how many hours you got? Jadamas. So I mean the backlog is massive, and it has been moving. We kind of looked at it.
Well, So what actually says it was sort of follow-up here is that as it's so massive, the visa bulletin can only advance 3 months every fiscal year. Insights, is it really that backlogged in the employment categories? So Sam's gonna take over the computer. I want to say, sorry, Sam. Think about COVID. Think about 2020. The visa bulletin moved at a maximum degree. There are outside factors beyond just the numbers that control these things, I guess, is all I would say.
So, I mean, just a quick look here. We are in February 10th, February of 2025, right?
Yep.
So here's February 20, let's look at February 2024.
That's a fairly scientific, unscientific way to figure it out. I like it.
Well, it's random.
Yeah.
Okay, so here's February, right?
Yep.
And let's pick a, I want to make it rest of the world.
That's fair. Yeah.
Okay, rest of the world. And we're going to make it EB2.
EB2, rest of the world.
So November 2022.
15th of November 2022, okay.
November 15, 2022. So I want to put it down here, November 15, 22.
Yep.
All right, so how much it moved? How much it moved now?
February 25th.
So
Dates for filing or final action?
that's a good question. I think it was final dates for final action. I think it's the first one.
Yeah.
So here you go, Brian.
1st of April 2023.
Yeah. So April 2023.
Well, that's 5 months right there, Sam.
Yeah. November.
That's 6. Yeah, 5 months. 5 months.
So 5-6 months per year.
No, that's 6 months. I'm a dumb. Yeah, 6 months. About 6 months. So 5.5 months is what it was in the end.
Yeah.
Sam, I'm going to go crazy. I'm going to just check out this India one real quick because you made me.
So which one you want?
These are final action dates, and this is February. It's 15th of October 2012.
Okay, October 12. There's a EB2.
That's EB2. Yeah.
Okay.
And just because I.
What year was it?
That was February 2025. Right.
What year was the priority date?
Oh, sorry.
2012.
Yeah.
October 2012.
15th of October 2012.
Okay.
And I'm going to go back to 2024. I'm going to go back to February. I'm going to go down to the final action dates for
India. EB2.
1st of March 2012.
So that's okay. March. So March.
We're beating.
April, May, June, July, September, October. 6 months.
Yeah.
So it moved. So there's two of them. 6 months movement in 1 year.
Yeah.
Not great, but
Oh yeah, that's
2 to 1
for your date coming up. Yeah. But
2 to 1. So if you have a 10-year priority date.
Yeah. Now we can obviously go back, but I mean.
This is 2 snapshots.
Yeah. Just a little peek. Yeah.
All right. Okay. Let's take the next one.
Yeah.
So Narek, hello Sam and Brian. If I am on a tourist visa and want to do a change of status to an F1 or E2, I want to overstay my B2 by applying. Would I overstay? I guess by applying. What are the chances of both scenarios? Okay, so assuming you are on an E2 visa country, Narek, which, for example, Pakistan is, most Europe is. Canada, Mexico, Japan, and a few countries in the Middle East.
Egypt.
Egypt, Jordan, Israel.
You're better than me. Yeah. I just happened to be looking into one for Egypt recently, yeah.
Yeah. So I think B2 to an E visa is very possible. Not a problem, provided that the funds are available, the business plan is available, you have time left on your B visa, and we can file a timely E visa for you. That shouldn't be a big deal. And F1, I think F1 would count to be more challenging because it takes a long time to find a school, to get an I-20, to get a sponsor.
Premium processing available now for
an
F1.
F1.
Yeah, I guess my take is premium processing available for both of those right now. The premium processing for F1 is 30 days versus the
normal 14 days.
Normal for the E2, it's done on an I-129, so that's the upside and the downside. But I guess I would point out that, I mean, think about your 90-day rule, though, which might be back. If you're here on a B visa, you're not supposed to be doing activities contrary to that.
Well, they're not doing it.
I know this is true. As soon as I say it isn't right. You're allowed to start a business on an E2 business on a B visa, and you're allowed to look for school on a B visa. No. So there is that.
The B2 and F1 visa has been frowned upon historically because the consulate like to have the purview of approval of these F visa applications. So the problem I see with the B visa to F visa, Brian, is going back to the home country and finding out that you enter on a B visa and you bypass the consulate and get an F1 visa. They don't like that.
Well, okay. So I imagine I agree with you, right? But you think which one do you think they're going to be more irritated about? Your B to E to E2 or your B to F?
The B to F.
You think?
Yes.
Well, E2s, that's consulate bread and butter. They've approved those things, the big packages, or sensibly sized packages anyway?
It's the consulate bread and butter, correct, but that's a businessman. He put a business plan and he invested money.
Yeah.
And created jobs, arguably. Yeah. And trust me, they're not looking forward to having to study this big package.
Yeah, the USCIS is better equipped for E-visa.
There are certain countries, however, where their E-visa review at the consulate is tenacious.
Painful too. Yeah, long. Yeah.
And the requirement, I mean, I have came across, without going into specific, where they need a CPA, signatures, and so forth in their foreign affairs manual for these countries, on their embassy website. So which is very tough. So you can bypass that and not do that.
Do it from inside the United States, yeah.
But that's the insight. Let's take the next one.
Well, a little bit more. Also, if I have an approved EB3 and EB2 approved, does the priority date from EB3 transfer to EB2 via the transfer underlying basis? Do you need to file a whole new I-140 for EB2? So the short answer is, as long as your priority date is rightfully gained, you can use your earliest employment-based priority date on any subsequent filing.
Right, but if he says he has an EB2 and EB3, I read it that he has an approved I-140 in EB2 and approved I-140 in EB3.
Okay.
So for me, my reading of it is he has it already. Why is he asking, do I need to file a whole new I-140
Yeah, that's how I was reading it.
for
But
EB2?
Yeah.
So if you have I think we're missing some information.
Yeah.
Brian, take that one.
Rasu Reddy, I'm H-1B. Can I start MS online graduate degree program by taking full-time load while maintaining my regular 40-hour work week? Also, can I later use this degree for an H-1B extension? So, bottom line is you are allowed to attend classes while you're on H-1B. And that's my short answer there. There's nothing that bars you from taking a full time of classes, but I guess in your heart of hearts, you're on the United States in a working visa, and I would just say, well, you're supposed to be maintaining your immigration status, and that's that. You have anything to say about? I mean, the disconnect there, going on a full-time load as a student. There's something in it that bothers me that I can't quite articulate.
Well, because a full-time study requires an F1.
Yep.
Full-time work requires an H-1B.
Yep.
Full-time both. We don't have a visa that does that necessarily.
Yeah.
Because the idea is that you're doing a supplementary part-time as you're maintaining your H-1B as your full-time. When you take full load on both of them, you really are dividing your time 50-50, which is start to
muddle your H-1B, I guess, right?
And all what you need is a little bit of a weirdo officer looking at your case that's going to give you a hard time. Normally, I don't see that as a problem. It's just you're inviting an opportunity to be questioned. So I would prefer that take an extra semester and drop to below full-time.
Yeah.
In my opinion, to protect yourself. It's a smart business.
Yeah, I don't consider it very unlikely this question, but I have. There's a reason why I don't like it. It's the fact that what you're doing in the United States is supposed to align with the visa. You're coming to work. You're coming to work on an H-1B visa, and if you're doing I'm going to use another example. So people sometimes ask us about passive income, and if you're having an H-1B visa, you're allowed to trade stocks on the sides, but you hit a magical inflection point where that becomes, you
become a day trader.
You become a day trader, and that's what I worry about in that scenario, to draw a comparison. Yeah. Well, Sam, what good timing! It appears we've answered everybody's questions, and it's just about 7 o'clock, the time we usually end this thing. All right. So thank you guys for listening to us. We appreciate your time. Come back at 6 o'clock, and remember, immigrationquestions.us. And why US? No, not because it's cheap. As a matter of fact, it's very expensive. Was it? Immigrationquestions.us. Yes, very expensive. All right. It's because it's U.S. immigration law. Drop your questions there, and we will answer them for you.